Hi, this is Annie Banerjee. I am an immigration lawyer in Houston, Texas, and today I'm going to talk to you about business-based immigration visas. We are talking about permanent residency through an employer. What does an employee and an employer have to do to have the employee permanently in the US so that the employee can keep working in the United States for this employer forever? As you know, the other kind of visas are non-permanent temporary visas. H-1B, for instance, is given for a maximum period of 6 years. L-1A for 7, L-1B for 5. Various other visas like O and P visas are given for 5 years. So there are those are temporary visas. But say an employee has been working with the employer is very happy with the work, and they already they can't find anybody else to fill the position, then the employer can petition for the green card for this employee. This process, the green card process, is a 3-step process. The first step is called Perm. P-E-R-M, it's an acronym, and it's for Permanent Labor Certification. In this step, the employer has to prove to the Department of Labor that there are no Americans qualified to do this job. We look at the job, and first we see what is that job. We have the job description, and then we ask the employer what is the very minimum requirement to do this job. Can this job be done by somebody with just a bachelor's degree? Can this job be done by somebody with an associate degree, or does it need a master's degree? And depending on what the job requires, we will the United States Citizenship and Immigration Service assigns the employer assigns categories for preferences. Second preference is a job that can only be done by somebody with at least a master's degree or with bachelor's degrees plus 5 years of experience. So obviously this job is a harder job to do. It requires a lot of research, and it's a senior level position, as opposed to an EB3, which is the third preference, employment based third preference, where the job can be done by, say, a bachelor's degree holder or an associate's degree holder, or even skilled workers. Skilled workers are workers who have certain skills that are rare in the United States. For instance, machinists, or any type of machine work, or any type of work that requires a special skill. But United States, we don't have that many folks to do this job. Now, so how does the employer prove that there are no Americans to do this job? The Department of Labor has prescribed ways to prove and do a recruitment effort, and if nobody qualifies, no American citizen qualifies for this job, then the labor is certified. So before we can file this labor certification process, the employer has to go through a lot of hoops. The first hoop is the employer has to pay a prevailing wage for that job. Now then what happens is that the employer crafts a job description, says what is required, what is a minimum requirement to do this job. the employer cannot require, for instance, somebody from Harvard, or the employer cannot require somebody with knowledge of a lot of languages, even if that helps with his customers, say knowing a language. It still cannot be required unless the job absolutely needs to be done by somebody who with those skills. For instance, say if somebody, if an employer who has a lot of business in, say, South America, they want to hire somebody who is fluent in Spanish so that they can talk to his customers in Latin America. Well, say the job is for a management position where they have to talk to people in South America to sell the goods, or or make purchases or whatever. That job cannot be advertised as requiring Spanish speaking, because the American citizen can always learn Spanish or look up Duolingo, or do the Spanish translations or whatever it is. However, if the job is for a Spanish teacher, then yes, the employee, the qualification required to teach obviously is knowing Spanish. So once the job is crafted, then we apply with the Department of Labor to find out how a prevailing wage is. Prevailing wages are filed through with the Department of Labor through this new system right now that came up in July, called the flag system. Prevailing wages can take anywhere between 2 months to 3 months to maybe even 5-6 months. It depends, and we also have to bear in mind that the Department of Labor's year ends on June 30th. So if we file a prevailing wage in January, by the time it comes out, if it is May, then the Department of Labor gives us very little time to do the job. So then we come to the to do this job, and thus we have they give us very little time to advertise this job. So after we get the prevailing wage, then the Department of Labor prescribes where we have to advertise this job in order to recruit American workers. Now, Department of Labor obviously wants to advertise in their website. Then they want 2 major Sunday newspapers, which are in the newspapers which are the major newspapers of that area, plus 3 other places. So it could be, for instance, if you're in Houston, it would have to be Houston Chronicle 2 Sundays, and then 3 other places. The employer could put it up in their website. They could use Monster. They could use a community newspaper if they wanted. They could put it up in schools recruitment for that area, maybe University of Houston. They could have a radio announcement of a job. So we have to advertise in the Department of Labor's website in 2 newspapers, Sunday newspapers of the newspaper in major circulation. For instance, if we have a job in Houston, we have to use the Houston Chronicle. We cannot use, say, Houston Press or some other newspaper. Similarly, if it is in New York, it has to be the New York Times. You cannot advertise in, say, New York Post or any other of those advertisements. Yeah, you can do 2 Sundays in New York Times and then also the New York Post, but you cannot do New York Post in and of itself, because that's not the major newspaper in New York. The major newspaper is New York Times. Now, this recruitment in the Department of Labor's website takes about 35 days because they have, once you apply for this job, they have what is called a veterans hold. So at that time, the job is only available to veterans, and then it goes to the general public, and it has to be at least 30 days with the general public. During this time, the employer also has to post for that job in a place of their employment, in a major place where everybody can see it. Then the employer has to conduct interviews and recruitment process. So if an American employee applies for this job and they qualify, then the employer is obligated to have this person, and the employer is obligated to, if it's just for one person, then the employer has to have the American person. They cannot have the alien. Now, if the recruitment goes well and if there are no Americans to do this job, then one can file a labor certification application telling the Department of Labor, hey, look, we advertised in all the places you asked for and we are not finding anybody, so let's give this person a labor certification. Now, remember, before this employer has hired this employee, they also probably did a recruitment. So this is kind of like a double recruitment process. If there are Americans to do this job, then it's much cheaper for employer to just have an American do this job. They don't have to file anything costly, or they really don't need to spend money, which they need a lot of if they employ an alien. Now, the labor certification, if it is not audited, some of them are audited at random, but if it is not audited, the labor certification is generally certified within about 5 months. After the labor is certified, then the alien, then there is another step for the employer to do, and that is called the I-140 process. This process has no other name except for the form that you have to use, which is the I-140. At this stage, I-140 stage, the employer has to tell the CIS, the Citizenship and Immigration Service, that look, the Department of Labor has already certified this job, this alien, and this job we have already proved that there are no Americans to do this job. And then they have to prove to the CIS, U.S. Citizenship and Immigration Service, that number one, that the employer has the ability to pay the employee, and second, the employee has the qualifications that are in that job description, which is the minimum amount. Now, for the I-140 stage, say the job requires 5 years of experience plus a bachelor's degree. Now, the alien cannot have that experience with this particular employer. Why? Because the rationale behind it is that if the employer had employed this person and given him 5 years, 2 years, whatever experience, then the employer can actually also hire a United States citizen and then give that person the experience. So the experience that we are talking about has to be had after the education that is required for the job and before this alien started working with this employer. So, for instance, the employee graduated with a bachelor's degree in, let's say, 2010, and the job requires at least a bachelor's degree plus 5 years of experience. Then this I-140 stage, the employee and the employer needs to prove that after the bachelor's degree in 2010, the employee worked for somebody else in that same field, in that same job, for 5 whole years, i.e., 60 months, not 1 day less. They have to work for 60 months, and and they have the experience and the bachelor's degree. Now, sometimes also what happens with the degrees is that the law says they have to have the degree, not degrees. As you know, the bachelor's degree program in the United States is for 4 years, and very often bachelor's degree programs in other countries, in India for instance, or UK, bachelor's degree program can be 3 years, and then they have a master's degree program. Now, let's say the bachelor's degree program is for somebody is an ordinary BS, which is Bachelor of Science. They've studied physics, chemistry, math. And then in the master's degree, they studied computer science, and the job requires a bachelor's degree in computer science plus 5 years experience. Now, the CIS can hold and will in the present time hold that this person does not have 4 years bachelor's degree in computer science. Why? Because it says degree and not degrees. The 3-year degree that they have is in physics, chemistry, mathematics, not in computer science, and then the master's degree is just 2 years. So one has to be careful about drafting the job descriptions. It has to be the minimum required. It also has to be such that the employee does have the minimum requirement of education and experience to do this job. The third thing is that the employer needs to prove that they have the ability to pay the employee. And there are 2 ways of paying of an employer to show that they have an ability to pay the employee. The first way is that they have net profit. Net profit, we are not talking about gross, net profit higher than what the employee has to pay, what the prevailing wage was, and what the employer had offered to pay in their Perm certified labor certification. So, if for instance, let's say that the job requires 100,000, if the employer has shown a net profit of 101,000, it's fine. But if they have a net profit of 99.999 thousand, then it's not fine. Even for that 1%, it's not fine. The employer, however, and this happens in a lot of companies where, especially bigger companies, where they do have, they take, for instance, deductions, and they zero out their net profit, or various other tax strategies where they have a negative balance. Now, the employer can then have already paid the alien that amount of money. So if the employer has promised that they will pay $100,000, or let's say $120,000, that would mean that the employee has to be paid about $10,000 a month. So let's say the Perm was filed in January, it gets approved in May, and the I-140 can be filed, say, in June. So the the total amount for the year is 120,000. So if the employer has paid this employee by June 30th, the amount of 60,000, then that is all right as well. So the employer has clearly paid this employee, and therefore the employer has the ability to pay. So then we move on, and if not, there are other ways to prove that the employer does have an ability to pay, but it is much more complicated. We can show a history of payment, and that for certain things like recession, the company may not be doing well, but they have already employed a lot of employees. They've already established business, and that is an iffy solution, but it can be made. The arguments can be made. So let's move on to the last and final process, which is called adjustment of status. That is AOS. Adjustment of status is when the employee is already here on an H-1B visa or an L-1 visa, and they adjust the status to become a permanent residency. And this process can also take place in the consulate level. It does not have to be AOS. It can be in the consulate level. But what we need for an AOS is that, number one, the visa number has to be available for that person's place of birth, and the person has to be in status. And in status means that they really have to have maintained status. Any blips in status, any gaps in status for more than 6 months is not going to get the employee the labor certification. So the employee has to give all the documents showing that they had been, from the day they entered this country, they have been in status. Now let's look at the countries.